Part 8 Realm and Commonwealth by Stephen Spiers. Copyright 2018. The Australian Law Journal, Volume 48, Number 1, January 1974. Current topics. Appointments to the High Court of Australia. The recent appointment of Mr. Justice Jacobs, President of the New South Wales Court of Appeal, to fill the vacancy on the High Court bench occasioned by the death of Mr. Justice Walsh, means that the High Court, with a composition of 4 New South Wales justices, 2 Victorian justices, and 1 Queensland justice, will continue to be representative only of the 3 eastern states of the Commonwealth of Australia. This has been the position now for more than a generation. While of course one cannot know to what prospective appointees approaches were made by the present Commonwealth Government, it is difficult to believe that in Western Australia, South Australia and Tasmania there are no lawyers or judges of sufficient ability or distinction to be appointed to the High Court and willing to accept such an appointment. Section 71 of the Constitution of the Commonwealth lays down that the judicial power of the Commonwealth shall be vested in, inter alia, a federal Supreme Court, to be called the High Court of Australia, giving emphasis to the word federal. It is certainly arguable that the draftsman of the Constitution intended that the High Court should, in its composition, be representative of all states of the Commonwealth, and not, as a matter of long-standing practice, of 3 only. Moreover, there is reason to think that the appointees from Western Australia, South Australia or Tasmania could contribute a fresh but valuable viewpoint to the judicial approach of the court as a whole. Many people might go so far as to feel that the 6 Australian states and as well the group of Australian territories should each be represented by a judge on the High Court, if that court is to be a truly federal Supreme Court within the meaning of S 71 of the Constitution. The term Australian Government. The present government of the Commonwealth of Australia has in a number of different ways made known its dislike for the terms Commonwealth of Australia and Commonwealth Government, and its preference for their replacement in official usage, as far as legally possible, by the appellations Australia and Australian Government respectively. In Canberra, the practice of substitution of the changed nomenclature has already gone very far. One important illustration may be given. On 2nd July 1973, the Commonwealth of Australia Gazette was renamed the Australian Government Gazette, and all subsequent issues have borne this title. The last issue of the Gazette to be published under the old title was number 79 on 30 June 1973. This alteration in the title of the Gazette was preceded by an amendment made by the Acts Interpretation Act 1973, assented to 19th June 1973, to the Acts Interpretation Act 1901 to 1966, whereby the term the Gazette was to mean the Commonwealth of Australia Gazette, published before the relevant date, and the Australian Government Gazette after that date. Also, Par A of S 17 of the Principal Act was deleted and replaced by a provision declaring that the term Australia or the term the Commonwealth should mean the Commonwealth of Australia. In his second reading speech on the bill containing these amendments, the Minister for the Capital Territory said, C. CTH Parl Debs 24th May 1973, page 2642. The bill also contains provisions to give effect to the government's intention to use wherever possible the term Australia to signify the Australian nation. This involves adopting the name Australian Government Gazette in place of the Commonwealth of Australia Gazette, the use of the imprint Government Printer of Australia instead of Commonwealth Government Printer on official documents, and the use of the term Australia instead of Commonwealth in legislation. Incidentally, also commencing in February 1974, the periodical publication Current Commonwealth Publications, CCP, listing available publications issued by Commonwealth departments and instrumentalities, has been retitled Current Publications of the Australian Government, CPAG. The official use of the new terminology by the Commonwealth ministers and by the departments based in Canberra prompted a decision in January this year by the Victorian State Cabinet that Victorian government departments, instrumentalities, and agencies should thenceforth use the term Commonwealth Government in preference to Australian Government in correspondence and communications as far as practicable. In a circular to the Victorian State Departments conveying the terms of this decision, the Secretary of the Victorian Premier's Department pointed out that there is no authority in the Australian Constitution for the use of the term Australian Government. All references in the Constitution being to the entity, the Commonwealth of Australia. While the Federal Parliament was described in that instrument as the Parliament of the Commonwealth, the circular concluded with the following parenthetical paragraph. It is realised that some Commonwealth departments and agencies have been renamed by statute to introduce the term Australian Government, and these titles will have to be accepted. This does not, however, affect the general application of the Cabinet decision. Apart from the point that the Australian Constitution makes reference not to the Australian Government, but to the Executive Government of the Commonwealth and to the Parliament of the Commonwealth, other objections to the rejection of the word Commonwealth are A. That the use of the term Australian Government implies that the government in Canberra is the government of the whole of Australia, whereas by reason of the division of powers under the Constitution, this is not true, since Australia is governed by 6 state governments as well as by the government of the Commonwealth, and B, that the word Commonwealth well portrays the political fact that the Federation of Australia is a union of peoples of distinct from a union of governments. While the Constitution does not expressly authorise the use of the terms sought to be promoted by the present Commonwealth Government, nevertheless, it would seem that, provided certain limits are not overstepped, such promotion is legitimate. These limits to the sponsorship at an official level of Australian Government and Australia can better be illustrated than closely defined. For example, in the absence of amendments to the Constitution, the Commonwealth Parliament and the Commonwealth Government could not legally prohibit officials and the members of the public from the use of the terms Commonwealth of Australia, Government of the Commonwealth, and Parliament of the Commonwealth, these being laid down in the Constitution, nor semble compel them under threat of legal process to use these substitutes, Australia, Australian Government, and Australian Parliament, where the constitutional terms would otherwise be appropriate. Again, in proceedings in the High Court, the Commonwealth could not appear as plaintiff or defendant on the record as Australia, but only as the Commonwealth of Australia. The High Court itself, a creation of the Constitution, would naturally insist upon the Commonwealth being given its formal name and style under the Constitution. On the other hand, the renaming of the official departments and of official publications so as to refer to Australian Government rather than to a Commonwealth Government does not run counter to any constitutional prohibition. It may be of interest to recall that the emergence of the term Commonwealth to describe an Australian federation was more or less a case of historical accident. At the 1891 convention summoned to consider the subject of federation, the Constitutional Committee voted for Commonwealth by a majority of only one, and if that committee had not supported this appellation and allowed it to appear in the draft bill to constitute the Commonwealth of Australia, presented to the plenary session by Sir Samuel Griffin as chairman of the committee, it would probably never have been adopted. C. Lanau's The Name of the Commonwealth of Australia, 15 Historical Studies, 1971, at pp. 60 to 61, and the same authors, The Making of the Australian Constitution, Melbourne University Press, 1972, at pages 138 to 139 and 152. Delegates and members of the public regarded the term Commonwealth as having to some extent a republican connotation, inconsistent with loyalty to the British Crown. Indeed, as late as January 1900, Queen Victoria seemed to think the use of the term reflected an anti-monarchical intention, and she doubtless would have preferred the word Dominion. As it was, the vote in favour of Commonwealth at the plenary session of the 1891 convention was 26 to 13. In view of the Victorian government's endorsement of Commonwealth early this year, it may seem ironic that in 1891, subsequent to the convention, the Victorian Parliament rejected the term Commonwealth during its consideration of the draft bill. Lanau's 15 Historical Studies, 1971, at page 62. At a later convention, that of 1897, Sir Hosea Simon, a South Australian delegate, argued unsuccessfully that the name of the Federation should be simply Australia. In the period 1891 to 1900, the term Commonwealth continuously gained ground and became generally accepted. Sir Henry Parkes was entirely responsible for suggesting Commonwealth to the 1891 convention. It has been said that this reflected his admiration for the statesmen of what was known as the Commonwealth in the period of Cromwell's administration prior to 1660. See Harrison Moore, The Constitution of the Commonwealth of Australia, 2nd edition, 1910, at pages 65 and 66. But other historical evidence indicates that the name Commonwealth appealed to him for other reasons of a literary and historical nature, while he could not have overlooked the appearance in 1888 of Bryce's classical work, The American Commonwealth, since he and other statesmen of the Australian colonies were so concerned with the United States as a model for the proposed Australian Federation. Lanau's 15 Historical Studies, 1971, at pages 63 to 69. Finally, it may be mentioned that in the period 1891 to 1900, many influential persons supported the name Commonwealth. Edmund Barton, for instance, later to become first Prime Minister of the Commonwealth, defended the name, saying, "I venture to assertion that I know of none better and none statelier." Lanau's The Making of the Australian Constitution, Melbourne University Press, 1972, at page 138. Establishment of a Commonwealth Legislative Drafting Institute. The establishment in Australia of a Legislative Drafting Institute was foreshadowed at a meeting of the British Commonwealth Law Ministers in London in January 1973. Legislation for this purpose under the names of the Legislative Drafting Institute Bill 1973 was introduced in the Senate, and its significance and scope explained by the Attorney General in a second reading speech delivered on 12 December 1973, from which it emerged that the proposed institute is to fulfill the following aims. 1. To provide instruction and training in the skills of drafting of legislation and the ordinances and regulations so as to ensure a continuing supply of draftsmen to be employed by the Commonwealth Government in the Office of Parliamentary Counsel and in the Attorney General's Department, which latter department became responsible in 1973 for the drafting of the subordinate Commonwealth legislation. 2. To provide similar instruction and training for persons to be employed by the Australian states and also by other countries, particularly the less developed nations experiencing difficulty in securing the services of a sufficient number of skilled legislative draftsmen to meet their special needs. 3. To foster interest in and encourage suitably qualified persons to enter the profession of legislative drafting. 4. The undertaking of research into methods and techniques used in legislative drafting with a view to the progressive improvement of those methods and techniques and the development of new techniques. These are enlightened aims. As the Attorney General pointed out, there is already a precedent for such an institute, namely a Canadian body established in Ottawa. The Canadian Institute has, however, been able to accommodate only a limited number of trainees in legislative drafting, so that the proposed Australian Institute should contribute towards the providing some part of the assistance sought by overseas countries, which they have been unable to obtain. The new institute is to be funded by means of monies appropriated by the Commonwealth Parliament from time to time, and to be under the control of a director appointed by the Governor General. The director may appoint full time. The next matter is the matter of abolition of appeals to the Privy Council. Last Tuesday, Mr. Heath and I had a valuable exchange of views about this matter. I had earlier discussed it with the Lord Chancellor, Lord Hallam, the Secretary of State for Foreign and Commonwealth Officers, Sir Alec Douglas-Home, and the United Kingdom Attorney General, Sir Peter Hawlinson, QC. The outcome of the discussions in London is that the Australian Government will introduce a bill as soon as possible requesting and consenting to the enactment of United Kingdom legislation abolishing appeals to the Privy Council in the remaining instances in which appeals still lie from Australian courts. The bill will draw upon all powers available to the Australian Parliament under the Statute of Westminster and under the Constitution. The purpose of the Australian Government is to make the High Court of Australia the final court of appeal for Australia in all matters. That is an entirely proper objective. It is anomalous and archaic for Australian citizens to litigate their differences in another country before judges appointed by the government of that other country. This is not the first time that the abolition of appeals to the Privy Council has been raised in the Australian Parliament. We can see a major shift occurring, but to the general eye it doesn't seem to be all that intrusive, given that the Commonwealth of Australia has been trying to be a self-governing society since its creation by Henry Parkes, and in 73 years of attempting to do so, it had always had someone else calling the shots. But something sinister was going on. Something was not quite right about these changes. And it wasn't independence from the United Kingdom of Great Britain and Ireland that started at the Balfour Declaration of 1926. It was that the very realm itself was being fractured. Most people had concentrated on the demise of the Commonwealth of Australia, but little had realised that the imperial crown itself, the anchor of the realm, lay in the balance as it sat empty for 20 years. A major shift was about to occur throughout the Commonwealth of Australia due to the actions of ministers in the Parliament of the Commonwealth of Australia under the Prime Minister of the day, Gough Whitlam. Sweeping changes were occurring across the Commonwealth of Australia and reaching down into every department. It had grabbed the states in financial arrangements with the Commonwealth and grabbed a whole of the Commonwealth from within. The people were about to go through a massive change, which would later be sold upon the people in green and gold by Bob Hawke's Labor government. Your allegiance to the former birthright was being changed, literally behind your backs in secret meetings between Gough Whitlam and the Queen in April and June of 1973, both here in Australia and overseas in the United Kingdom. Some of the key issues at stake were the nationality of the Commonwealth of Australia by way of a change to the Oath of Allegiance, change from being in allegiance to a realm into being in allegiance with a nation state, and following changes to the national anthem, parliamentary oath, oath of office, and the introduction of the Order of Australia. A foreign power in a realm had now secured the realm by way of the Queen of Australia, proclaiming a coronation of Queen Elizabeth II by way of Australia being termed in oath of allegiance to United Kingdom of Great Britain and Northern Ireland, and negated the United Kingdom of Great Britain and Ireland, Kingdom of Australia, formed post-Imperial Conference 1926. The foreign realm had begun to change the Commonwealth of Australia from its core relative to the realm itself. The introduction of the St. Edward's Crown and a newly named British Parliament, along with separation of kingdoms in royal style and title 1927, had put the Commonwealth of Australia in a precarious moment in time wherein the actual core of the faith is being brought into question. Department of the Prime Minister and Cabinet. Confidential. Mr. Bailey, Mr. Grigg. Royal Style and Titles. Following the approval by Cabinet this morning of the Prime Minister's submission, it is now necessary for instructions to be given to the Parliamentary Council for drafting of a bill. Would you please prepare a letter? I would like to see it before it goes. We should let the draftsman know that the Queen has asked to have approval of the legislation reversed for her personally and also the signing of the necessary proclamation. Her private secretary suggested she might give assent when she is in Canberra in October. It occurs to me that the Prime Minister might want earlier assent, but I will take that up with him separately. EJB, E.J. Bunton, Secretary, 1 May 1973, confidential. The Royal Style and Titles. 1. The Prime Minister has indicated that he wishes the Royal Style and Titles Act 1953 amended to delete references to the words by the grace of God, of the United Kingdom, and Defender of the Faith. 2. The Queen's Royal Style and Titles for Australia is recounted in the schedule to the Royal Style and Titles Act No. 32 of 1953 attached. The position is similar in Canada and New Zealand. 3. A number of Commonwealth countries have adopted Royal Style and Titles omitting reference to by the grace of God and of the United Kingdom. They have also omitted the words Defender of the Faith. These countries are Sierra Leone, Sri Lanka, Nigeria, Tanzania. 4. The forms adopted by Jamaica, Trinidad, Uganda, and Fiji include the words by the grace of God. 5. However, these countries have retained as a common element with their other Commonwealth titles the description of the sovereign as Queen of her other realms and territories and head of the Commonwealth. There was consultation between these countries and the Australian government when they proposed making the changes. 6. Omission of the three phrases will affect a number of instruments wherein the Royal Style and Titles are used in relation to Australia and its territories, i.e., the seal, royal warrants, commissions of appointment, etc. 7. There may be some controversy over the exclusion of by the grace of God. The phrase has been continuously associated with the title of Queen or King since the reign of William Rufus, the coronation being recognised as a Christian ceremony. 8. All the Christian realms except South Africa add Defender of the Faith. Some people will no doubt take strong exception to the omission of the words. However, there is no established church in Australia. 9. It is strictly a matter for Her Majesty's ministers in the country concerned to decide whether to change in the royal style and titles is relevant to their circumstances. In the case of Australia, it would be expected that we should seek Her Majesty's informal approval before proceeding with legislation to omit references. Formal approval could be sought after the views of other Commonwealth governments had been attained. These countries might then be advised formally when the new title was brought into use. Honours Branch, Department of the Prime Minister and Cabinet, 10 April 1973. Proposed amendments to Citizenship Act, including Oath of Allegiance. Synopsis. The process of naturalisation entails appearance at a citizenship ceremony. The certificate of citizenship takes effect only after an oath of allegiance is sworn. On the other hand, Australian citizenship by registration is conferred upon citizens of Commonwealth countries as soon as certificates are issued. There is no ceremony and no oath. The new oath of allegiance will be as followed. I, AB, swear by Almighty God that I will faithfully uphold the Constitution of Australia and I will faithfully observe the laws of Australia and fulfil my duties as an Australian citizen. The two principal features of the new form of oath are that A. It omits the words renouncing all other allegiance. B. It omits specific reference to the Queen. Department of Immigration, 10 April 1973. C. Applicants should be able to speak English and understand it when spoken, and should understand the responsibilities and privileges of citizenship, but with exception, as at present, for the elderly and the handicapped. D. There will be no change in existing requirements of the Act as to mental capacity, good character, and intention to continue to reside in Australia. E. All persons over 16 years of age, including citizens of Commonwealth countries who are granted certificates of citizenship, should take an oath or make an affirmation, and the oath should be taken, as at present, at a formal ceremony. F. The new oath of allegiance will be as follows. I, AB, swear by Almighty God that I will faithfully uphold the Constitution of Australia and I will faithfully observe the laws of Australia and fulfil my duties as an Australian citizen. 7. The two principal features of the new form of the oath are that A. It omits the words renouncing all other allegiance. Comment. These words had no legal effect and caused deep concern to many people who have wanted to be Australian citizens without having to forsake their attachment to their former homelands. B. It omits specific reference to the Queen. Comment. People from non-British countries often cannot understand that the Queen is Queen of Australia as well as of England and have been bewildered by having to swear the present oath in order to become Australians. By swearing to uphold our Constitution, they will, of course, be undertaking to uphold the monarch's present position in our Constitution. Misunderstandings. 8. There have been some misreporting of the above proposals, and it has been necessary to emphasise that citizens of the 31 Commonwealth countries who do not become Australian citizens will not be aliens. They will continue to have the status of a British subject. This status is described in some Commonwealth countries as Commonwealth citizen, and as such, those who have settled in Australia. Confidential. Dear Martin, I write to add background for your preparations for the discussion the Prime Minister will be having with Her Majesty. The subjects of discussion seem likely, and I understand it to include possible changes in the royal style and titles in coinage, in arrangements for letters of accreditation, in the designation of our High Commissioners, and in communication between the Australian states and Her Majesty. There is also to move towards our own distinctive national anthem. The Prime Minister's thinking about a possible change in the royal style and titles is a response to the developing identity of the Australian nation and an attempt in that context at achieving within Australia a more immediate identity between Her Majesty and her Australian realm. Two adjustments suggest themselves immediately in this context. One is the possibility, with the advantages in Australia it would carry, of making Australia not only the principal, but the single named realm in the recital of titles. To this end, the reference in general terms to Her Majesty's other realms and territories would stand, but the existing specific reference to the United Kingdom would be omitted, as it has already been in some other Commonwealth countries. The other is the possibility that Her Majesty's Australian style and titles would include a reference to Elizabeth rather than, as now, to Elizabeth II. Any such changes would, of course, involve legislation, but before proceeding to this or to any public discussion, the Prime Minister feels he would like to have the opportunity of consultation with the Queen herself. Other particular phrases in the citation which have come under discussion here are the reference to Her Majesty as Queen of the United Kingdom and the descriptions by the grace of God and defender of the faith. On coinage, the point for discussion will be the designation II appearing after Elizabeth on Australian coins. It links with the point referred to above. Mr. Comans on 27/4/73. Copies sent under compliment slip 2. Confidential. Parliamentary oath. The Australian Constitution prescribes in section 42 that every senator and member of the House of Representatives shall, before taking his seat, make and subscribe before the Governor-General or a person authorised by him an oath or affirmation of allegiance in the form set forth in the schedule to the Constitution. 2. The oath in the schedule, which has remained unchanged since Federation, is I, A.B., do swear that I will be faithful and bear true allegiance to Her Majesty Queen Victoria, her heirs and successors, according to law. So help me God. Note: the name of the King or Queen of the United Kingdom of Great Britain and Ireland, for the time being, is to be resubstituted from time to time. 3. In discussions concerning the amendment to the Oath of Allegiance in the Citizenship Act 1973, which is before the Parliament, it may be appropriate to refer to the parliamentary oath as an expression of the loyalty of parliamentarians to the Sovereign. Department of the Prime Minister and Cabinet, 11 April 1973. National Anthem. Your Australia Day broadcast on the National Anthem was cabled to Australia House on 26 January and a copy was forwarded to the Palace. Background. Your government's decision to ask an alternative anthem in the culmination of a long history of pressure exerted by the growing number of Australians for a national song with a distinctly Australian flavour. You made it clear in your Australia Day announcement that the intention is that the new anthem should be played on those formal occasions when patriotic sentiments are appropriately high. For example, an Australian win at the Olympic Games. The present anthem, God Save the Queen, will be retained for use on occasions when Her Majesty or a representative appointed by her is present at functions in Australia. This practice besides giving Australia a popular song to identify the spirit of the country at home and overseas, will bring us into line with other Commonwealth countries, notably Canada. The competition. Following your Australia Day address, more than 700 entries have been received, many from overseas. Those include original melodies and lyrics and expressions of support for the traditional Australian songs. Other letters request entry forms and details of the competition. A working party of the Australian Council for the Arts has drawn up details for the competition. These await your formal approval. The current thinking of the Council is that the competition should be open only to citizens and permanent residents of Australia. Copyright of the winning entry being vested in the Australian Government. This will effectively disqualify the majority of entries from the United Kingdom. The royal visit in October. In any discussion of the matter you have with Her Majesty, you could mention that it appears unlikely that a final choice of anthem will have been made prior to her opening the Opera House in October, an occasion when God Save the Queen would be used anyway, according to the policy announced on page 2 of your Australia Day message. This is in view of the decision of the Australian Council for the Arts to extend the duration of the competition from 3 to 9 months. Department of Foreign Affairs, Outward Cablegram. To Australian High Commission, Ottawa, 339 Secret. Personal in confidence underlined. For Wilson only, from Bunting. Some preliminary thinking is taking place in relation to the royal style and titles, which for Australia currently read as follows. Elizabeth II, by the grace of God, of the United Kingdom, Australia, and her other realms and territories, Queen, Head of the Commonwealth, Defender of the Faith. 2. We have noted that some countries, not including Canada, have omitted one or both of the phrases by the grace of God and Defender of the Faith. 3. The subject may be discussed during the visit of the Prime Minister to London, April 20 to 26. 4. To assist in preparing briefing material for the visit, I would be grateful for any information you can obtain about any approaches either made or in contemplation by the Canadian Government to Her Majesty on either phrase. 5. You will recognise the extreme delicacy of this matter. Because of this, it should be raised only in the strictest confidence and on the basis that any approach you make is exploratory in nature and on a strictly informal basis. There would be no quotation in any discussions in London of any information you may be able to obtain. 6. Grateful for early advice. If a suitable contact is not available, we would prefer that the matter not be raised at all. Australian High Commission, London. Inward cablegram. Confidential. Immediate. 6339. For Bunting. From Bailey. Your 6412. Debate on royal style and title will took place in the House of Representatives on 18 February 1953. Apart from Sir Robert Menzies and Dr. Evatt, Mr. Josky, Mr. Robertson, Mr. McColl, Mr. Lukac, Mr. James, and Mr. Osborne spoke. Prime Minister Whitlam has not a speaker on this occasion. The opposition speakers, in the persons of Mr. Evatt and Mr. James, gave the bill full support. Sir Robert Menzies' second reading speech extends over 9 columns of Hansard, and a summary follows. The passage relating to of the United Kingdom and Defender of the Faith are quoted in full. The speech of Dr. Evatt was much shorter, and the text is quoted below in full. It seems that neither of the two leading speeches need cause any particular problems in explaining the changes now to be made. Sir Robert Menzies, after a general explanation of the decisions which were taken at the Conference of Prime Ministers in London in December 1951, said in part, confidential. 6. Omission of the three phrases will affect a number of instruments wherein the royal style and titles are used in relation to Australia and its territories. For example, the seal, royal warrants, commissions of appointments, etc. 7. There may be some controversy over the exclusion of "by the grace of God." The phrase has been continuously associated with the title of Queen or King since the reign of William Rufus, the coronation being recognised as a Christian ceremony. 8. All the Christian realms except South Africa add Defender of the Faith. Some people will no doubt take strong exception to the omission of the words. However, there is no established church in Australia. 9. It is strictly a matter for Her Majesty's ministers in the country concerned to decide whether a change in the royal style and titles is relevant to their circumstances. In the case of Australia, it would be expected that we should seek Her Majesty's informal approval before proceeding with legislation to omit the references. Formal approval could be sought after the views of either Commonwealth governments had been obtained. These countries might then be advised formally when the new title was brought into use. Honours Branch, Department of the Prime Minister and Cabinet, 10th of April 1973. We can see through secret meetings between Gough Whitlam as Prime Minister of the Commonwealth of Australia and Queen Elizabeth II, Queen of Australia by Royal Powers Act 1953, inferring power to her through the Governor-General of the Commonwealth of Australia under the United Kingdom of Great Britain and Ireland, that a change of oath of allegiance is taking place, and at the same time the removal of the wording "by grace of God" and "Defender of the Faith" from the Royal Style and Titles 1953, wherein a queen not only of a foreign kingdom to the realm is now also wearing a foreign crown to the realm. A crown noted so clearly in royal styles and titles under Queen Victoria, Edward VII, and George V to be imperial specifically. Now we have royal style and titles referring to the realm as the crown, and visually distinctive yet very specific heraldically is the use of the St. Edward's crown and not the imperial crown linked to the legacy of Queen Victoria we have laid out at the beginning of this paper. United Nations being linked to the citizenship under trust territories of the Commonwealth of Australia, now with a Queen losing the title of God's Grace and Defender of the Faith of the Commonwealth of Australia. The people having their very core oath of allegiance changed and becoming citizens of a foreign nation state to the former birthright left in inheritance by Queen Victoria. Royal Warrant, Elizabeth R. To our Governor-General of Australia. With this you will receive a great seal prepared by our order for the use of our Government of Australia. Our will and pleasure is, and we do hereby authorise and direct that the said great seal be used in sealing all things whatsoever that shall pass the great seal of Australia. Our will and pleasure further is, that you do cause the great seal that accompanied our royal warrant given at our Court of Government House, Canberra, on 16 February 1954, to be defaced by you in our Executive Council of Australia. And for doing so, this shall be your warrant. Given at our Court of Government House, Canberra, on 19th October 1973. By Her Majesty's command, Whitlam, Prime Minister. Royal Warrant, Elizabeth R. To all and singular to whom this warrant shall come, greeting. Whereas by our warrant, given this day at our Court at Government House, Canberra, We authorise and directed that a Great Seal prepared by our order for the use of our Government of Australia be used in sealing all things whatsoever that should pass the Great Seal of Australia. And whereas it is desirable that the said Great Seal be used as a Royal Great Seal for certain purposes. Now therefore our will and pleasure is, and we do hereby authorise and direct, that the said Great Seal be used as a Royal Great Seal in sealing all things whatsoever, other than things that pass the said Great Seal, that bear our sign manual and the counter signature of one of our Ministers of State of Australia, given at our court at Government House, Canberra on 19 October 1973, by Her Majesty's Command, Whitlam, Prime Minister. Royal warrant is issued for the Great Seal of Australia. We can slightly confirm the design below as the Great Seal of Australia through its use on gazetted letters patent reconstituting the office of Governor-General of the Commonwealth of Australia for Quentin Bryce's tenure in office in 2008.